Hi guys! Welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we take up part 12 on the law of obligations and we'll be talking about natural obligations as well as the principle of Estoppel. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Before we begin, let's just differentiate civil obligations from natural obligations. While I did this in my first episode in the obligations series, let's just do that again today for the sake of discussion. Okay? In civil obligations are those obligations which give a right of action to their enforcement before the courts. Okay? In other words, civil obligations can be enforced by court action, no? While natural obligations are not based on positive law, meaning they're not in the provisions we study, and they do not give a right to enforce the performance, no, before the courts. However, after voluntary fulfillment by the debtor, voluntary fulfillment by the debtor, the law authorizes the retention of what has been voluntarily delivered or rendered. Okay? So, in other words, the creditor can now keep what the debtor had voluntarily delivered or rendered. Okay? The binding tie here is merely the conscience of man. Okay? And as long as the juridical tie is not prohibited by law, and this is not given effect until it has been voluntarily fulfilled by the debtor. Okay? So in other words, until the voluntary delivery or performance by the debtor, then there is nothing to be enforced. Okay? But in case the voluntary fulfillment is already done, then the creditor is allowed by law to keep the thing and the debtor can no longer recover what he has delivered. Okay? Now, there are natural obligations which can be converted into civil obligations, okay, such as a promise to perform a natural obligation. This one may already be enforced, okay, because it has already been promised, no? Or in case a natural obligation has been novated or ratified, okay? Please just watch my videos on novation and ratification under voidable contracts, no, to learn more. But in case of novation and ratification of a natural obligation, then they may be treated as a civil obligation which may now be enforced in courts. Okay? Now, before I discuss some of the examples, no, I just want to remind you that prescription, no? Prescription is a mode of acquisition of rights or extinguishment or loss of rights. Okay? So you can either gain rights or lose rights through the passage of time. Okay? And there are different rules on prescription. Okay? Now, for the purpose of natural obligations, here are the rules. No, I just defined prescription first in order to give context for the rules on natural obligations. Okay? The voluntary performance of an obligation after that obligation has prescribed, okay, is a natural obligation, no? In which case, the creditor can keep the thing, no? Or and the debtor is not allowed to recover what he may have voluntarily delivered, okay, or rendered, no? When an obligation prescribes, no, there is no more any right to enforce it through the courts, okay, because that is extinctive prescription, okay? So you lose your right to enforce that action. And in case the debtor voluntarily performs that, then the rules of natural obligations apply and the retention of the thing or service rendered is now authorized. Okay? Second example, no? Reimbursement of a third person who pays a debt of the debtor after it has prescribed, no? Okay? Let's say that the debtor has to repay a third person who answered for the debtor's debt to the creditor and that obligation has expired. Generally, the debtor does not have to reimburse the third person. But if the debtor voluntarily delivers the reimbursement, no, then the third person is authorized to keep what has been delivered to him, no? And the debtor cannot recover. Okay, third example, no? Performance or voluntary performance after the action to enforce it before the courts, no, has failed. So let's say a party files a case in court to enforce a civil obligation, but he loses. The court says, no, you lose, you are not entitled, no? However, after that final judgment, the debtor comes now and says, okay, I'll just perform na lang. In that case, the rules on natural obligations apply, and the creditor may retain what has been delivered or rendered, and the debtor cannot recover what has been voluntarily delivered or rendered. Okay? Next, payment by an heir of a debt exceeding the value of the property inherited, no? Because as a general rule, an heir is only liable to pay the debts of the estate to the extent of the assets of the estate. No, if the estate no longer has any properties or other assets with which to pay for its debts, then the heir will no longer be personally liable for those debts. However, under the rules on natural obligations, if the assets of the estate are already depleted and there are still debts, and then the debtor voluntarily pays those debts, then the creditor who receives that payment is allowed to retain that, and the debtor cannot get it back anymore. Okay? Because the payment has been voluntarily made. And finally, the last example would be payment of a legacy. What is a legacy? It's a gift of personal property given through a will, no? Last will and testament. Payment of a legacy after the will was declared void. Okay? Since the will in this case was declared void, it should produce no rights. It should transfer no property. Okay? However, if one of the heirs still pays that legacy to the person named in the will, even though the will is void, then the law allows retention by the creditor of the thing or legacy received. Okay? And the debtor who delivered it voluntarily cannot get it back. Okay? For more information on successional rights or inheritance law or estates and the heirs, no, please just watch my series on succession, no? There is a playlist available. I'll just link it in the description below, okay? Now we can move on to the principle of Estoppel. And what is Estoppel, no? Estoppel is simply a condition or a state by virtue of which an admission or a representation is rendered conclusive upon the person making it. Okay? And it cannot be denied or disproved against the person who has relied thereon. In other words, walang Indian giver, walang no takebacks, no? What you said will be held against you. Okay? What you did will be held against you. That's Estoppel. Okay? Now, what are the kinds of Estoppel? Let's talk about the first kind, the Estoppel in pais or by conduct, no? Then I'll give a few examples. So the law says that these are actually supported by other laws, no, such as sales agency, no, or the laws on security and credit transactions. So let's say in the case of a contract of sale, no, if a person who does not have title to property passes it to the buyer, and that person who sold it subsequently acquires title, then of course the title passes by operation of law to the buyer. Okay? Another example would be if the agent sells property belonging to the principal, then he cannot raise his own right, no, or title to that thing as against the buyer, because he has already represented himself to be an agent. Another example, no, the lessee or the bailor cannot set up title against the lessor or bailor. Okay, again, the lessee or bailee cannot set up title against the lessor or bailor, because that the person has received that thing under the concept of lessee or bailee already, and he cannot deny the title of the lessor or the bailor. Okay, so those are in pais or by conduct. Now, there's also under in pais and by conduct, we also have Estoppel by silence, no? This is in Article 1437, no? of the Civil Code, no? This is in case of a contract concerning an immovable where one person misleads another, okay, as to the ownership or real rights over a real property, no? And the person who has been misled, okay, the person who has misled the other cannot assert his legal title or interest over that real property if the following requisites are present, no? Okay, he'll be held to his own representations if first, the fraudulent representation or wrongful concealment of facts is known to the person committing the fraud. Okay? Second, the party at fault intends that the other person, the one who was misled, okay, will act on those misrepresented facts. Third, if the party misled is unaware, he does not know the true facts. And finally, if the party misled acted according to the misrepresentation. Okay? So, that's estoppel by silence. So, an example only, no? And then, we also have acceptance of benefits under 1438, no? So, one who allows another to assume apparent ownership over personal property for the purpose of transfer, no? Cannot if he received a sum of money for which a pledge was constituted. He cannot set up his own title to defeat the pledge made to a pledgee who received the thing in good faith and for value. Okay? To learn more about pledge, please just watch my episode on pledge under the playlist security and credit transactions. Okay? Now we can go to the second kind of estoppel, which are the technical estoppels. We have first estoppel by deed, no? In which case, a party to a deed, no? His party to a deed, he cannot assert a material fact which is contained in the deed, no? Against the other party. Okay? He cannot assert a material fact which is in the deed against another party. Estoppel by record. It's the next kind of technical estoppel, no? You cannot deny the truth of matters set forth in a record, whether it be a judicial record or a legislative record, no? And those are the two kinds of technical estoppels, no? Let's go now to the third kind of estoppel, estoppel by judgment, okay? And under estoppel by judgment, a party cannot deny facts which are adjudicated by a court of competent jurisdiction. Okay? And finally, the last kind of estoppel is estoppel by laches, no? And laches is simply the doctrine of stale demands. This is the failure or neglect to for an unreasonable amount of time to do that which, okay, to do that which by exercising due diligence could have or should have been done earlier. Okay? And in other words, it is the negligence to assert a right within a reasonable time. Okay? And this warrants the presumption that the party who is entitled to this has either abandoned or has declined to assert his right. Okay? Now, there are certain elements for laches to apply. And first, of course, there must be conduct giving rise to a situation for which relief is sought or the complaint is made. Okay? Second, there is a delay. This is the most important, no? There is a delay in asserting the rights, having knowledge or notice of the defendant's conduct and an opportunity to sue or file a case. Okay? Third, lack of knowledge or notice, no, of the defendant, no, that the complainant is asserting a right on which the complaint is based, no. And finally, there is injury or prejudice to the defendant if the relief is granted or if the suit is not barred. Okay, so that's laches. Just remember, for laches, it's just a failure to assert your right. Now, you have to be diligent when you assert your rights, no? Do not sleep on your rights and bring it within the proper time. Otherwise, you will be guilty of laches and you will not be allowed to claim the relief you are asking for. Okay? So that's it for natural obligations and Estoppel, which concludes my series on obligations. Okay? And you can proceed to part 2 on the law on obligations and contracts, namely on, well, contracts, no? I'll link in the description below to link you to the playlist on Philippine contract law. Okay? So I hope to see you next time. Okay? Bye!